Good afternoon, everyone. We're going to allow just another minute or so to let attendees continue to sign on. We all appreciate you taking the time to be with us this afternoon. All right, good afternoon, everyone. My name is Ashley Voice-Levovich. I'm the research manager at the Charleston County Criminal Justice Council, and welcome to the Charleston County CJCC's webinar, What's New in Charleston County Centralized Bond Court's Pretrial Assessment. Our panel of experts will discuss the background and use of pretrial assessments in Centralized Bond Court, including recent updates to the Charleston Pretrial Assessment Instrument. Discussions will focus on the application of pretrial service reports, also known as PSRs, as well as guidelines for interpretation and limitations. At the end of the formal presentation, we invite you to participate in a brief Q&A with the panel. As a reminder, this webinar is being recorded. During the presentation, attendees may submit questions through the chat feature, which we will present to the panel during Q&A. Again, thank you so much for joining us today. And with that, I am happy to introduce the Honorable Judge Amanda Haselden. Judge, take it away.
Thank you. Good afternoon, everybody. My name is Amanda Haselden, and I am a Charleston County Magistrate Court Judge. I am currently assigned to Bond Court. We have a centralized bond court here in Charleston County, handling all charges in the county with the exception of North Charleston and City of Charleston municipal court cases. I have been on the bench since 2019, so I'm in my 6th year here. And during the entirety of my time as a Charleston County Magistrate Court Judge, we have been using pretrial assessment tools in some form. Risk assessments, as they are used here in Charleston, are documents that provide judges and attorneys with an estimated risk of failure or success while out on bond. And as you can see from the current screen, it is a 2-page tool. And I believe we are the only county in the state of South Carolina utilizing a pretrial assessment tool in bond court at this time. You can see the first page has some personal information and some various data that's pulled, and the second page is the actual assessment that does indicate the different levels down at the bottom right of that screen. And you can't see it on this page, or maybe it's just because this is a blank. There would be under the points column there different numerical values assigned in the applicable spots that ultimately lead to an assessment of risk level or success level down at the bottom right. If we could go to the next screen, please. So all of this is based around statutory requirements here in South Carolina. And South Carolina Code of Law is 171510, as you see on your screen, is sort of the basis of analysis in bond court. And it essentially says that everyone's going to be released. Our default is release unless we are able to determine as a bond court judge that release will not reasonably ensure that that person's going to come to court, or if we believe that person poses an unreasonable danger to the community or a certain individual. Going on to the next screen, it's important to take into account an additional statute dealing with bond 171530. Because 171530 provides a list of factors that you can see up in section A that I may consider, and then a list of factors that the court must consider. And this pretrial risk assessment tool mainly focuses on the factors that I am required to consider in each and every bond hearing, primarily the person's criminal record, if they have any other charges pending or all of the charges pending at that time in the current case. I'm also required to consider incident reports, whether that person is an alien unlawfully present in the United States, whether that person is a documented gang member, whether that person is out on bond already. So prior to the bond hearing, down further in 17-1530, which was cut off for purposes, just space purposes on this slide, it also lists what items are required to be provided to the bond court prior to bond hearings. They're required to give me a full criminal history. That includes both previous charges and convictions and any charges that are currently pending against that individual in any other jurisdiction or state. And I'm required to get an incident report and then any other information that would assist this court. So ultimately, a bond court judge is or should summarize all of that required information provided both prior to that hearing by law enforcement, but also at the actual hearing. In Charleston County, we are fortunate that we typically have present a representative from law enforcement, a public defender or private lawyer. The defendant often has supporters, and sometimes the defendant also wants to be heard. And then I have victim advocates and victims, and all of those individuals give me a variety of information during that hearing and prior to that hearing in order for me to make the most accurate assessment that I can on whether somebody is a danger in our community or to a specific individual, if they are a risk of flight, or if they should be released on their own personal recognizance. So the PSR is so incredibly helpful because what it does is it streamlines that process for me. It condenses a great deal of information that I'm required to consider into a 2-page format for faster analysis. Quite often, rap sheets that I'm required to consider can be tens, if not well in excess. I've had multiple that are upwards of 50 pages. That's a lot of analysis. So we are in our third version of this tool here in Charleston County. It's called the CPAY. Charleston Pretrial Assessment, but it's from my perspective as a bond court judge and the person who sits on the bench in bond court here in Charleston more than anyone else right now. From my perspective, it is one of the tools that I use. It is a fantastic tool that I use to try and make that ultimate analysis. It saves me time, and it's also a vital second set of eyes looking at this information that I'm required to go through. I go through rap sheets, and I'm not only looking at prior convictions, I'm looking at the number of times people fail to appear and other factors, and I can cross-reference my findings with what is on that PSR, and if I notice a discrepancy, that's a cue to me to go back and look for more. It tells me if somebody's on probation or parole without me having to dig into the probation website for each and every defendant. So it is truly an invaluable tool here. And so how I use it in bond court is exactly what I just stated, but I also want to stress that it is not and should not be used entirely on its own. No document can truly consider someone's danger to our community. It is an excellent resource at analyzing data for prior convictions, whether they be felony, misdemeanor, pending charges, failure to appears. But it is imperative that I also consider that second factor, whether somebody's a danger or not. And this most recent version, as I'm sure Kevin or Anthony will discuss at some point as well, it only goes back 10 years. So while 10 years, oftentimes if you've been in bond court, you'll hear about someone's prior history, and we focus on the last 10 years. That is not mandated anywhere in the law. I'm required to consider prior history, doesn't say 10 years, but for convenience purposes, that's oftentimes what's focused on. But a prime example of a reason I would not utilize this tool on its own is that on occasion, people have been convicted of serious or violent crimes, and they have been imprisoned for the majority of the past 10 years. So their pretrial risk assessment tool may indicate they have no prior convictions and no failure to appears because those were outside of the 10 years, when in fact that person has been incarcerated for most of the past 10 years. So, you know, it is certainly one of the many tools that I use, but it is not and should not be used on its own. So I wanted to clear up that misconception. We always have concerns for consistency in bond court, not only because cases are different, people are different, but we want to treat everybody as evenly as possible. We have a variety of judges that come in. We have a different night judge that comes in during the week, and we have a different weekend judge that comes in on Saturdays and Sundays, and then all judges in Charleston County rotate through on holidays. So consistency is key, and it also assists us with sort of analyzing consistency across the board, lower risk levels, typically leaning towards PRs, higher risk levels, typically being considered for sureties or no bonds. But consistency is a goal, and it's a tough goal, but it is one that we strive for. And the reason we have people and not machines or mandated bond amounts, with the exception of magistrate and municipal court charges, is so we can take into account how each case is different and hopefully make accurate findings. Local data has been used, which is really important to consider. This is, like I said, the third version of this, and we have been able to successfully use local data right here, Charleston County data, to reinvent this tool twice. So far, we are on our third version. We went from VPRE to CPRE to CPE. And that is to ensure that this tool is as accurate and up to date as possible. So I get to use the most accurate and updated risk assessment tool to hopefully, the ultimate goal is to have the most accurate goals and most consistent goals in analyzing whether somebody is a risk or is a danger or should be released pre-trial. I am happy to take questions at the end of this seminar, but before then, I am going to turn it over to Kevin Kuehmeier, one of our justice systems partners, who will be able to really explain more of the science and wizardry behind this amazing tool. Thanks.
Thanks, Judge Haselden. And, you really did hit on a lot of elements of this, and I'll just give you a quick intro and explain who I am and my history actually working in the county. I work for Justice System Partners and have been with them for 7 years and do various work across the country related to criminal justice work. And I do spend a lot of time working in jurisdictions specifically around pretrial assessments and quality assurance and all of that, and educating system stakeholders on this. My prior life, I worked as an administrator and practitioner in the federal probation and pretrial system. In the second half of my career, I did a lot of education and training on not just pretrial assessments, but on post-conviction assessments. So I'm very familiar with all this, and even just nationally where things are going in this field. So as Judge Haselden already mentioned, you are fortunate in your county and one of the only ones in the state that is using this as something to kind of help inform decisions. So we're going to talk about the background. We're going to talk about what are pretrial assessments, why use them, why pretrial assessments has changed in Charleston County, how the CPA or the Charleston Pretrial Assessment Instrument can be interpreted, what are some of the limitations of it, and then we'll open it up to some questions and discussion. So what are pretrial assessments? And you know, this type of education, I think, is really important for stakeholders and for people that do touch this to kind of really understand, you know, what are pretrial assessments. So they estimate the likelihood that people will appear in court and remain arrest-free while in pretrial release. Most pretrial assessment tools, that's their purpose and what they are. And notice that it's likelihood that people will appear, and it's the assessment tool doesn't give you a prediction based on the person that's in front of you. It's for like people that that are like that individual that have the same characteristics. So so it's not unique to that individual, but it is an assessment that has the same characteristics as the person that's appearing before the court. They're research-based, and they use factors that help predict the chances that an individual succeed. And success is defined as somebody not getting rearrested and somebody appearing in court versus failure, which is the opposite of that. So somebody getting rearrested or somebody getting a failure to appear warrant for them not coming to court. So those are really the only two factors that that is used for these assessments. Actuarial assessment is very common, not just in our field in the criminal justice field, but also in other fields. We see them in healthcare. We see them in car insurance. So if you have a male driver or a female driver in your household and they're of the same age, you understand that the male driver's car insurance is higher. Well, why do we know that? Well, we know that because actuarial assessments show us that male drivers get into more accidents. They take more chances and all of those. So that field certainly uses assessments to kind of help set car insurance. So the last bullet down there really talks about them helping inform pretrial decisions to promote pretrial success. So, and we heard the Judge Haselden really talk about some of those other legal requirements that are part of this process. And then also there are opportunities for defense to present information and law enforcement and at that decision point, but this is to help aid that decision-making process. All right, so we're going to run through a couple of different reasons why this field uses pretrial assessments. This is garnered from the National Association of Pretrial Services Agencies that listed some of these reasons, and we'll kind of run through those because it's really it's a good exercise to really kind of understand why we use them. So it's a data approach that's used to predict and to help aid in that process. We do see that these assessment tools do predict, and the judge already alluded to this on the consistency factor. So I want to just show you a graph, and this was taken from some training. Actually, I was involved in this training. It was in the federal system. What we would train new federal probation and pretrial officers, and we would have them watch a vignette, and we would have them watch a vignette of an assessment of individuals that were appearing for the first time to help them assess the individual. So they watched the video, they had some background information on the person, and you can see this graph here. After that vignette was shown, after they had the information, that's all they had, they then used their judgment on what risk level they thought that individual was. And you can kind of see this graph really varies across different areas and what people thought their level was. So small amounts thought low, some people thought low moderate, a good portion thought moderate, and then some people saw this person as high risk when they watched this vignette. And this is over a period of time, over doing this training over several years. So then during the same process, we would then train the staff on how to score this tool properly using the same person, but based on using an assessment tool. And this is now accumulation of how people then scored the person after they used an assessment. So you can kind of see now, we see that this individual was in this low moderate category. So so you can see the consistency really narrowed, and then majority, 90-some%, will see this individual in this level. So it's a good exercise at just really having that consistency factor that, Judge Haselden was talking about earlier, and it really does, in the field, it really does help with that. So another advantage, and we see our little box here, number 2, it's used to really, research uses it to help us predict what's the pretrial misconduct, is it consistent among staff for similarly situated defendants, and then it increases this standardization and transparency in the bail setting process, ultimately increasing the public's confidence in bail decisions. This graph here really kind of shows, I would say, how your tool, the CPAY tool, predicts and the outcomes of different, if somebody was released on either personal recognizance or a financial bond was set. So you can kind of see level 1, right? Those are the people that are most likely to succeed. Those individuals were given the highest level of PR bonds. And then it decreases as their likelihood of success decreases, which is what you would hope would happen in a situation. So this just validates the process and the outcomes that have been set in your jurisdiction. All right, so we're on to number 4. It really helps maximize the rate of pretrial release. So, we see in our, in our system that, we encourage, right, if you saw the statute for South Carolina around maximizing release and thinking about individuals that should be released on their own recognizance, we see that the Supreme Court and Justice Rehnquist in a landmark decision in 1987 said that release should be the norm in our society and detention should be the limited exception. So we're not saying that individuals shouldn't be detained, that should be detained, but that release should be the norm in our system. Number 5, again, why we're using assessments. It helps pretrial agencies and courts really target services for people that are likely to succeed. And this item really, the point of this one is that there are individuals that are likely to succeed, and there are individuals that are not as likely to succeed. And we know that based on our assessment that helps us guide that. And we should focus services and things that would help them, individuals, if they were released, we should target any kind of services on those that are not likely to succeed. If people are likely to succeed, the research says we should really leave those individuals alone. So, so we want to maximize release. We want to maximize the time that they're in detention. And we want to think about release at the earliest stages, because individuals, we see also research that says that individuals, if they're going to be released, that it could harm them if the more time that they spend in detention. So we have to really critically think about that as well. Number 6 talks about this maximizing release, limiting pretrial detention. Number 7, again, advantages. This really helps jurisdictions move from this money-based system to an outcome-based system. The research is also fairly clear that money bail doesn't have a positive outcome on outcomes. So systems have to think about a system that doesn't rely on money bail and think about ways that money bail is used or not. Number 8 really maximizes, and you can see we'll see from Anthony Bishara, who's involved in the validation around looking at making sure that these assessment tools are race, gender, and ethnicity neutral, and that they don't exasperate any of those things. Okay, so this is a timeline here that, and you heard Judge Haselden really talk about the evolution of this. And you can see in 2018 here on our timeline, all the way on the left, we had an assessment tool that was implemented in 2020. That was another tool was introduced, and then there were some attempts to also update it, and I'll kind of run you through the reasons why it moved from the vPRE version to the CPRE version on the next slide. And one thing I want to point out is, similar to what we're doing now, this education piece, when the iterations were happening, there was a lot of collaboration with stakeholders to really educate them and inform them along the process, just as we're doing right now. The vPRE, this slide really shows that the vPRE is a statistically valid tool, but there's some limitations to it, and it requires an interview. You can see there's 8 items on that tool. The last 2 items require an interview. So to answer those questions, so there was difficulty in Charleston County at accessing individuals to be able to conduct that interview. So they had found that about 50% of the cases that were eligible were actually getting assessed because of some of those limitations. So systems in your county tried to think about an assessment that didn't require an interview. Other jurisdictions have also moved in that direction, and it didn't give up any statistically validness to the tool by not having an interview, but it added to the reach rate. So you can see down in the bottom then, when the CPRE was introduced, there were items that didn't require an interview. We saw that 92% of the cases then were assessed when that tool is introduced. All right, so we have our same timeline here, but then we, you can kind of see through the years that the vPRE is introduced, and I can tell you just from, again, being involved in this in other jurisdictions, that revalidating assessments and based on your population is the standard. So you're following that, and you want to continue to do that, and you're fortunate. I'll turn it over actually to Anthony Bishara from College of Charleston, but you're fortunate to have a system with people that can do these validations internally, which is really ideal. So I'm going to have him talk about now the latest process of how you validate it.
All right, thanks, Kevin. So yeah, I'm a professor at the College of Charleston, and I've also been a volunteer community representative with the CJCC since the start of 2020. And I've been heavily involved in this data analysis part of the most recent update to this pretrial assessment. We call these updates revalidations. And it's good to do these periodically. So the CPRE was, which was used in court from 2020 to end of 2024, it was based on data from our own county. So the CJCC used data from our own county. It was about 2,000 defendants. And while it led to this CPRE, which was an improvement on the vPRE-R because it didn't require an interview, as Kevin said, you still need to update these tools periodically because the crime patterns change, the criminal justice system changes, the laws change, and our data infrastructure improves over time as well. So we considered an update around 2022, but our data at the time was limited due to the pandemic. Because of the pandemic, it was there were large stretches of time where court wasn't happening, and so there were no failures to appear in court. And so we realized that we couldn't really measure that in the data at the time. So we ended up waiting and using a larger data set that spanned from 2020 to the very beginning of 2024, a data set that had over 10,000 defendants. And this also marked the first time that we had the capacity at the CJCC to analyze this data set and update the pretrial assessment in-house. So we use this larger data set for the most recent version of pretrial assessment. This most recent version, technically it was implemented in bond court in mid-December of 2024, but just for simplicity, you'll see it on the slides and listed as like the 2025 tool. This most recent version, you'll also notice that we got rid of the word risk to shorten it up a little bit, and so the R is missing in the most recent abbreviation of the tool. So then the question is, like, what were the substantive changes from the previous tool to this newest one that's just been used mainly in starting around the end of 2024? So the previous tool, the one used in court from 2020 to 2024, had 9 risk factors ranging from pending charges to violent convictions. And these risk factors were used to predict pretrial failure. Again, where failure means failing to appear in court or being rearrested during pretrial release. And when we analyzed the larger, more recent data set, it became clear, first of all, the good news was that many of these risk factors were still predictive of pretrial failure. But it was also clear that we could do a slightly better job predicting failure by making some small changes to the tool, as often happens when you update or revalidate these risk assessment tools. Here's the newest version of the tool, the version that you see in bond court today. The changes are highlighted. For example, it used to be that a defendant had to have at least 2 failures to appear for that to be considered a risk factor. The larger, more recent data set showed that it was actually better to use a cutoff of at least 1 failure to appear. Similarly, the data showed that we needed to update the categories for the different age groups. As before, though, older defendants tend to have a lower risk of pretrial failure. The data also showed that we could do better at predicting pretrial failure by adding a new risk factor for felony convictions. Also, the data indicated that sex and charge type were no longer helpful at predicting pretrial failure once these 8 risk factors were already considered. So you'll no longer see sex or charge type as risk factors on the newest version of pretrial risk assessment. As before, each risk factor is associated with points, and these points get added together to determine the defendant's risk level from 1 to 4, with 1 being the lowest risk and 4 being the highest risk. So if these tools are working as we intend them to, then the pretrial failure rate should be lowest for level 1 defendants and highest for level 4 defendants. And you could see that the old pretrial assessment tool, it was actually still working. The level 1 defendants had an 11% chance of failure. It was higher for level 2 and higher for level 3, and the defendants at the highest level, level 4, had a 42% chance of pretrial failure. You'll notice that we can never have a crystal ball. We're never able to predict a 0% or 100% chance of pretrial failure, and this is typical and normal. If you look at assessment tools used in other jurisdictions, you never get the certainty of 0% or 100%. Human behavior is just inherently hard to predict, no matter how much data you have or how complicated you make the tool. When we updated the tool most recently, we found a similar pattern, but the updated tool was able to do slightly better. That is, you'll see that the level 1 defendants in the updated tool are a little bit closer to 0% failure with a 9% failure rate. And the updated tool was also slightly better at identifying high-risk defendants and labeling them as level 4. You'll see that level 4 has a slightly higher failure rate than it did in the earlier version of the tool, and that is by design. We want the tool to distinguish between the highest and the lowest risk defendants, or at least as much as possible given the uncertainty of human behavior. If we didn't have a risk assessment tool, we would guess approximately a 20% failure rate, 20%, as represented by that dashed line here, is the overall failure rate of all defendants. So both tools perform better than simple guessing of 20% for everyone, and the newer tool is doing slightly better than the older one. We tested this tool for racial bias, and we found no evidence of racial bias in the tool. That is, higher risk levels from 1 to 4 are associated with higher pretrial failure rates, and this is true regardless of whether the defendant was Black or white. We did not have enough data on other racial or ethnic groups to test beyond these two groups. We also tested for sex bias of this new assessment tool, and we found no evidence of sex bias in the tool. Higher risk levels are associated with higher failure rates for both female and male defendants. When I first looked at this graph, by the way, this one bar popped out at me, and it might pop out at you too. When I looked more closely at the data, there was actually no significant difference in risk between the level 4 female defendants and the level 4 male defendants. And so the question is, like, why does it look so high here? What's happening is that extreme bar is a fluke of randomness. And the reason that happened is, out of this large data set of 10,000 defendants, there were only 27 female defendants who were at this highest risk level of level 4. And because there were so few people making up this bar over here, that it's a very unstable estimate of failure due to that small sample size of the data. So the bottom line is that higher risk levels from 1 to 4 are associated with higher failure rates. And that's true regardless of race or sex. Finally, you'll see that whether a defendant receives a financial bond, as shown on the left here, or a personal recognizance bond, as shown on the right here, that level 4 defendants are still more likely to fail than level 1 defendants. In other words, the tool is still predictive of pretrial failure, regardless or even across different bond types. If you're curious about the big picture for how the risk assessment changed in more detail, I've included a detailed overview slide. We'll share these slides by email with webinar participants later, so I don't want to spend too much time on the nitty-gritty details. I just want to highlight a few pieces here. Note that the point system changed in the updates, so you'll see some of the point values have changed, and if you've been in court over these different time periods, you may have noticed this as well. Also, we did consider additional risk factors, or at least ones that we had data for all defendants. So for example, we considered the possibility that having a pending weapon charge might predict pretrial failure. But when we analyzed the data showed that a pending weapon charge was not predictive of pretrial failure once those other 8 risk factors were considered. And for that reason, pending weapon charge is not listed as a risk factor in this assessment tool. So the point system did change. In the old version, each defendant would have a point total ranging from -1 to +19. We were able to simplify that to a 0 to 13 point system in this new version. The points get translated into those levels 1 to 4. You'll notice that the cutoffs have had to change as well because the point range has changed. This is the new version of pretrial assessment. This is what you will see filled out for a defendant. It's on page 2 of the Pretrial Services Report. A few parts to note on here. First, these factors highlighted over here, circled in yellow, they refer to the last 10 years only, and so it's possible for what's listed there to differ from a defendant's rap sheet. The reason the pretrial assessment relies on the past 10 years is that recent behavior tends to predict future behavior. For example, a failure to appear a few weeks ago is very predictive of a defendant's current behavior. But if a defendant had a failure to appear 30 years ago, it's not as helpful at predicting their current behavior. Rest assured that the bond judge can still see information older than 10 years in other records, and they can still take that information into consideration. The points for each risk factor, they get added up to that point total, and that gets translated into assessed levels 1 to 4. For example, if a defendant has 2 points, they would end up as assessed as level 1, that is the lowest risk. We know based on the data that 91 out of 100 defendants at that level succeeded pre-trial. In other words, 91% of level 1s didn't fail to appear and weren't rearrested pre-trial. And conversely, that means that 9% did fail to appear or were rearrested pre-trial. And although the pretrial assessment was really built to answer this question in this first row here, as a side effect, it also turned out to predict the chances that the defendant would or would not be rearrested on a violent charge in particular. And several stakeholders were interested in this issue of violence for community safety reasons. So we added this information on the bottom row of this table. So this is the violent rearrest information. It was not available on the older risk assessment. So for example, like if you know that a defendant is assessed at level 1, that tells you that 98% of similarly situated defendants were not rearrested on a violent charge pre-trial. Conversely, that means that 2% were rearrested on a violent charge pre-trial. Note that one other thing to note is that level 2 is the closest to the overall average success or failure rate among defendants. You may remember that the overall failure rate was only 20%. So that means that the overall success rate was 80%, which is closest to level 2. So I usually think of level 2 as being closest to the average or typical risk of a defendant pre-trial. All right, so with that, I think I'm going to pass it on to Kevin to talk about the limitations.
Thanks, Anthony. Anthony mentioned that we'll provide the PowerPoint. There's also links to different resources as well, or research sites that we have put into the PowerPoint. So those links will also be available to you. So we've really covered a lot of these, but with assessments, we know that there are limitations, that they do evolve over time. As you can kind of see, this is the third iteration of this, which again is the intent and the hope with jurisdictions, to do this certainly every 3 to 5 years and really norm it on your population. And then I'll kind of move across, but they're really valid at the time that the bond hearing is happening for which it was prepared. It's used also to help with setting conditions if conditions are imposed, or with services, and we'll talk about that in the next slide. Moving over to the left, then pretrial assessments were designed really to predict pretrial success or failure only, not connect anything related to the disposition or anything related to guilt or innocence. And then as we heard from Judge Haselden, and we'll reinforce it, that assessments are something to help in the decision-making process. So it's not meant to be the only thing that a court would consider or that a jurisdiction would consider. And we heard Judge Haselden talk about the statutory requirements that they're also considering in that decision-making process. We heard from Anthony Bishara as well that we know that this is attempting to this is looking at human behavior, so we know that there's no 100% chance of prediction, but you can really sense and you can see in this process that it does help aid in really understanding the population that you're working with. Okay, so the next slide is kind of a little bit of a look ahead and looking at the future of what pretrial services is. I know the Charleston CJCC is considering different options and kind of the what's next. So as you can see, and you can see in our analysis, that most people do succeed on pretrial. We really are, the goal of it is really to help assist with individuals to appear in court and to address public safety and reassure that people don't get rearrested. This process and if there are things that are set after the hearing, that the intent should be that it be individualized and that things should be least restrictive. And then what would a pretrial services look like in Charleston County? So again, they're considering what it might look like. A services approach is something that the industry and the field is going towards, and really trying to help individuals and address their needs, but also think about, and are there different assisting strategies that can help people get to court and lessen their chances of getting rearrested? So ultimately, if there is this approach and they're working through what that might look like, the intent is really to help individuals be successful, not get rearrested and to appear in court. We see different examples of those type of services down here on the last box. It could be maybe mental health assistance, getting them mental health treatments, or substance use referrals. Court reminders, we really do see that court reminders are a very effective way to get individuals back to court. They help all of us with getting to our personal appointments via dentist or doctor's appointments, and it works in our system as well to help people remember that they have court hearings. It could also be assistance with housing and those kind of things. So those are just examples of different services that could be used to kind of help individuals while their case is pending. So with that said, I think we're going to really transition to Q&A, but we're also going to prompt, we have Donna Taylor here as well, who she's on our webinar as well. We'll have her say hello, and maybe just she's from the defense side, and have her kind of present or just give a statement on just what she feels in her opinion is maybe a benefit to these assessments. So Donna, I'll just turn it over to you.
Okay, great. Thank you. Obviously information and data is helpful, whether it's good or bad, obviously depends on whether we like it and it's helpful to me or not. But definitely, I've only been doing this for a year now, so I've had the benefit of this my entire time here, but it's definitely helpful for couple of different reasons. Obviously, when Judge Haselden is on the bench, she does it 5 days a week regularly. She's been doing it for years. She's pretty comfortable with it, has her own, feelings and opinions for what kind of bonds work for what kind of charges and what kind of folks need. But we have often, every weekend, we have different judges who are not so comfortable. And I think that having this assessment that reaches a conclusion that supports something that might otherwise be difficult for them to do because they're not as comfortable with being the person that sets a bond that might put somebody out who might hurt somebody else, makes them more comfortable and able to do that hard call, which may or may not be an actual hard call, but for them, it makes them, I think, feel more comfortable that they have this other voice saying, yep, that's a reasonable thing to do. And there's statistical basis for it. I think the other really key factor is, as the judge mentioned, and you guys as well, we want it to be fair. We don't want any kind of bias, whether it's financial or racial or gender or anything else. So this is a document that achieves that goal as well. And it does make sense. Obviously, if somebody has a history of failing to appear, that should be something that you consider. I think it's important that we understand, I can't remember if Kevin or Anthony said this, but it's an excellent truth. Everybody has a past. And if you're 40, 50 years old and you have a criminal history that dates back, 35 years, that may not have any bearing whatsoever on the last 10 years of your life or 20 of your adult life, that you have not had those instances. And I think that makes a big difference. And that's another value to this document being used as well. But I find it very useful. I find it useful with the clients who are not always 100% forthcoming with accurate recounting of their history. So it's also helpful to kind of jog their memory when I'm interviewing them and they tell me, yeah, they've never, had any problems with court. They've never had a conviction. They've never had a violent conviction. They've never missed a court date. And if that document tells me otherwise, then I can jog their memory. So I think that helps as well, because it doesn't look good for the defense attorney to go in and present to our judge what they believe to be accurate facts, when in fact they are not. And they are also detrimental to the client, and worse when they don't admit it. So I find it helpful in many different ways.
Thanks, Donna. We appreciate that. And I know we put in the chat to feel free to ask any questions you might have. We'll attempt to answer those. I do see that there was a question asked, and it asked, what are some criteria used for electronic monitoring device determinations? So I'll start, answering that, and I'll maybe even ask Judge Haselden to add. So we do see with the research around different strategies that do have some impact on pretrial success. So we don't see strong evidence that electronic monitoring does have any impact on pretrial outcomes. We see one study that does show it for domestic related cases and select type of cases. But we don't see a lot of evidence that shows electronic monitoring has a positive outcome on predicting pretrial success. So that's a factor to think about. Now, that's a pretty restrictive type condition if it is imposed. So if it is imposed, it's certainly better than somebody sitting in custody if that is the intent to release the individual. So it's certainly better than that. And the other thing that I would maybe pose is that that the impact and electronic monitoring should be used for those people that are least likely to succeed, right? So that's kind of the individualizedness of it and the least restrictive side of it as well. So, it should be used for individuals if they're least likely to succeed, and should probably be used sparingly if used at all. But the assessment tool could certainly help with that determination, I would imagine. And I don't know, Judge Haselden, if you have anything to add on that.
Yeah, I kind of assumed that question was asking about specific points on the PSR. So in that manner, I would say the number one thing I would look at on a PSR would be the failure to appears. Obviously, on the front, it analyzes how many times someone has failed to appear in the last 10 years. It does not include driving offenses. So South Carolina DMV, I get a separate 10-year, if they have had a license for that long, a separate criminal history from DMV. It does not include those failure to appears. So the failure to appears contemplated on the PSR are the ones from NCIC, with magistrate, municipal, or general sessions level offenses that are not driving specific. So if I was trying to determine in just a random case, I would say the number one indicator would probably be failure to appears if somebody is actively not going to go to court. Because the main time that I probably impose electronic monitoring is in victim cases, and it's going to be from information provided to me either through an incident report or at the hearing that either an individual has repeatedly violated court orders to stay away from somebody or something, has consistently proven to be a danger or such an extreme danger that I have concerns about that for a specific victim. Or like I said, they consistently fail to appear.
All right, thanks, Judge.
Mhm.
And then And there was another question in here. How does pretrial assessments in Charleston compare to other jurisdictions? So, I mean, I can at least tell you from my perspective, in working with other jurisdictions on pretrial assessments, that, you know, you are on par, and it, you know, it's predictive as good as any other, you know, assessment, I would say, that, you know, that's being used. So, so I think you should be proud in your county that, you know, one, that you have had different iterations to your assessment tool, but then you also, you know, have the capacity to be able to do it internally. So compliments of, you know, Anthony and Ashley certainly being able to do that. So so certainly a benefit for sure. Okay, and then just another one came in. You know, and Anthony, please chime in here, or anybody else if you have anything to add to this, but or some of these other questions. But will pretrial assessments change in the future? Yes, they probably will. You know, that the intent is really that there should be a constant look at assessments, and that just like your iPhone, you know, is changing and you get updates to your iPhone, assessments should probably follow suit with that as well. So, so yeah, I would say it'll probably change in the future as we learn and know more, and validations are done across the country, and things are updated and validated. That yes, that the assessments from the beginning have changed from when they first started. So yes, I would say yes to that question.
Yeah, and I agree to all of that. I will just add that, yeah, the goal is to, do this every few years. I mean, 3 to 5 years, and each time we do it, hopefully, our data becomes better, and hopefully we could do a little bit better job and keep it up to date, and and also share, more information that everyone's interested in. So, for example, now we're sharing, information about being rearrested on a violent offense, and we weren't able to do that in previous iterations of this tool. And so, I'm hoping in future versions we could, continuously make improvements like that.
All right. Well, I think we're at time, or we're getting close, and I'll just, do a closing thought and just kind of say that, this education process, I think, is really important for people that are involved in the process to really understand it. The assessment's one component, but it can only be as good as the people that kind of understand the intent and the purpose. So this was really, I think, very appropriate and timely based on how you are all now using this assessment and in the context of it. So I think the intent is to think about this in the future and do this more as an opportunity for people to kind of learn and grow. So I'll turn it over to Anthony. So thanks for watching.
Yeah, thank you too. Nothing to add, and I know we're butting up against the 1:30 timeline, so I just want to say thank you, everyone.
Thanks. Thank you, guys.
Yes,
Judge
thank you
Haselden.
so much to our panel. The CJCC wishes to thank each of you for your time and insight for today's webinar. Thank you also to our attendees. We hope the time was insightful, and if there's any further interest or questions about what was discussed today, we invite you to please reach out to us at the CJCC. Again, we thank you for your time, and thank you to this amazing panel. This now concludes our webinar. Thank you again, and have a great day.